Hello, everybody, and good afternoon, and welcome to this session on licensing-based business models. My name is Tom Whittle. I'm with the European Patent Office, and this event is organised in cooperation with the European Innovation Council and is hosted by the European IP Helpdesk. Quick bit of housekeeping before we get started. This event will be recorded, and the recording should be available for you to view in some weeks. And if you have any questions, please feel free to put them in the chat at any point. We will have dedicated question and answer sessions at the end of each panel. So I'd like to formally open this. I have two colleagues, one from the EIC and one from the EPO. So Vera Pekka from the EIC, and then Patrice Pellegrino from the EPO. Virel, the floor is yours for the words of welcome.
Thank you, Tom, and good afternoon, everybody. And welcome to this training, licensing-based business models. This training is co-organized by EIC, EPO, and European IP Helpdesk in a very good cooperation, I must say. And it shows really the power of cooperation and synergies, and how, by just joining forces, we can reach to more of you and have more impact. This training is oriented towards EIC beneficiary, or at least from our point of view, but open to every European innovator, because we think that the questions, the problems are very similar, if not really similar. For the one, our vision is simple, yet powerful, or at least we think so. From idea to the market, we provide support to your ideas or via Pathfinder, previously FET or Future Emerging Technology. Then via the EIC transition, we provide further support towards innovation and the market. But not only if you come from Pathfinder or previous FET, but also from ERC, from Pillar 2 of Horizon Europe, even from FET flagships and so on. And with Accelerator, we provide closer to the market support from TRL 6 onwards, with both grants and equity. Recently, for focused on EIC transition and with the support of a colleague from GRC, we did recently an impact report, and one of the findings, not the only one, but perhaps the one a bit surprising and relevant for today, was that licensing as a pathway to market was not considered much by transition beneficiary and even some applicants. And again, remember, applicants are coming from outside, from the whole work program. Hence, the natural recommendation was to inform beneficiaries and applicants about licensing and other market entry strategies as alternative or even complement to more established pathways to market, like creating spin-offs of direct exploitation, which we like as well, no worry. So depending on the exact case, this could potentially increase speed and reduce the cost of bringing innovation to the market. But of course, licensing can also be combined with creation of a spin-off and or direct exploitation. So we think this would be useful not only for transition, but also for Pathfinder, Accelerator, ERC, and many researchers in Europe looking to exploit your research result. So that's why we decided to make this public and disseminate as wide as possible. It is really great to see so many participants, and I wish you a very fruitful participation, and please do not hesitate to let us know your feedback. Thank you.
Thank you, Virel. Patrice, representing the EPO.
Yes, so thank you very much, Virel, for your introduction. You know that the European Patent Office and the European Innovation Council have a long-standing tradition of partnering. We want to support innovators and entrepreneurs across Europe. We started cooperating back in 2022, and we formalized this with a letter of intent with EISMEA, but with a clear support to the EIC through the support that the EPO examiners provide to the evaluation of EIC proposals. Additionally, in 2023, the Patent Academy joined forces to offer targeted courses tailored to the needs of the EIC beneficiaries. And I'm very happy to say that the first major event that was held, it was the licensing as an exit strategy for the EIC beneficiaries, had an very overwhelming response with 500 registrations and many more afterwards after the recording. Then this was also followed by the publication of an open access article named Empowering the Licensing Capabilities of the EIC-funded Startup Companies, which recently ranked in the top 10 downloads on the Social Science Research Network. Today's event builds on this success, offering a further valuable insight and training. At the EPO, we believe supporting innovators goes beyond the grant of patents and means also valorization as a critical step to unlock the full potential of technology. Licensing is, of course, one of the key tools in this process, and I'm thrilled that we can offer this training today. I hope you find today's sessions valuable, and I do look forward to welcoming you at the future European Patent Academy events. Thank you very much.
Super. Thank you both for those very kind words of welcome. So without further ado, let's get into the main meat of the session, should we say. As I said, if you would like to put any questions, please feel free to put those in the chat throughout the whole event. And as I said, there are question and answer sessions after each part. So without further ado, I'd like to pass you over to my colleague at the EPO, Christian Saltman, to talk about Introduction to Licensing. Christian, the floor is yours.
Thank you, Tom, very much for the introduction. I hope you can hear me. Also, welcome on my side, and the pleasure to be with you today to shed light on different aspects of licensing. Today we will start with a brief introduction to licensing. It's just a teaser to allow you to understand the principles, the context in which licenses matter, some do's and don'ts. And you will hear more about details during the presentations of the experts later today. When we talk about licenses, I think it's good to take the helicopter view first in order to see a bit of context in which licenses matter. Let's take an example. For example, the example of a technology that you develop in the laboratory. Yeah, let's maybe start with an example. I took the example of additive manufacturing. Just look at this image here, a set of different aspects that matter when you develop products or services in that area. Of course, you develop devices, you develop materials, but that's not all. This is what we as scientists and engineers think about. But when you look closer at the product development process in startups, in companies, in industry, there's much more we in the laboratory take care of. For example, we do design work because we develop the outer experience of the product. It's not a raw product that will be sold on the market. There are other technologies that matter, maybe exchange of information with computers or other devices in a workshop or factory. Then programming matters a lot. Graphical and acoustic work, when you exchange information with the users, for example, someone operating a 3D printer. And of course, when you go to the market and try to establish a relationship with customers or future customers, then much more matters. Branding, you will use logos, product names, you will have to develop product videos, web pages, photographs, and much more. Today, you may be in the laboratory. The next step in your career is, of course, to be successful on the market. You try to bring a product or service to the market. So let's take the example again of this additive manufacturing device, which is surrounded by some outer experiences. You have software that you would like to bring to the market. Manuals, explanations, documentation, etc. This is where you want to be. Either you would like to use your own technology and be successful on the market yourself, or you may enter into a relationship with others in case you are not able or willing, for example, to commercialize the technology yourself. And of course, this is a commercial activity. At first sight, it may look like a piece of cake. So of course, there are risks, commercial risk. You need to take actions. You need to choose markets, establish legal relationships. But this is especially a special situation because you deal with know-how, with intellectual assets, and it's not a straightforward exercise to bring them successful to the market. Rather than a piece of cake, it's a slippery road, and that's due to the fact that your products, your services will be based to a large extent on know-how and information. And typical for know-how and information is that they can be reproduced from a technical point of view by everyone, usually at moderate cost. So if someone takes it, copies it, it creates a competitive advantage for them because they don't need to develop themselves. They can simply take the results of all the work you did, all the investments you did, the educational effort that was necessary to arrive at the technology. And second, once information is available to the public, it's from a technical point of view not possible to exclude others from using the knowledge and the know-how. And that creates really a barrier for you and an extra risk that you would not have if you were just commercializing physical items or physical property. Fortunately, there's a variety of so-called intellectual property rights that help you to secure your investment in the know-how in other intellectual assets. It's the set of intellectual property rights for different aspects of the know-how and other intellectual assets. Here you can see a list of major intellectual property rights that help to support you in commercializing your know-how. First of all, in the area of technology, patents really matter. Patents are legal rights that are granted for new technical inventions, usually after a substantial application and examination procedure. Such patent will be granted, allowing you to exclude others from certain commercial actions. I will use patents as an example in a few seconds. Second, there are other things you create. Work that is created, original creative and artistic forms, text, videos, but also software code. Copyrights start to exist automatically at the moment when the work is created. Then there are trademarks. They address signs which you use to exchange information with your customers or future customers. They help to protect distinctive signs that help to identify your products and services and allow the customers to distinguish them from the product and services of others on the market. Trademarks are usually obtained by a formal procedure, as are designs which help to protect the external experience. So for example, the outer shape, patents, etc., which are obtained using registration. There are unregistered designs as well, which are also useful in specific situations. And then last but not least, trade secrets, which help to protect valuable information which is not known to the public. So for example, confidential information, how you can operate a machine to reduce the error rate, as the requirement to have meaningful trade secret protection is that you take reasonable efforts to keep the confidential and valuable information secret. These are just the main intellectual property rights I would like to mention here. There are others also important, and the purpose is really to support you in securing your intellectual assets and make sure that you can tap the benefits from it, you who created these assets. Let's take the example of patents just to illustrate it a little bit further before we come to licenses. Patents, very important in any area of technology, help to protect technical inventions. Formally speaking, a patent is a legal title which grants the patent holder or holders the exclusive right to prevent others from taking commercial actions with the technology protected by the patent. So it's not an active right. Having a patent doesn't mean that you can use the technology on the market. In some areas, there are legal restrictions. You need authorization first, but it's an exclusive right, but it's a very important right, of course. The principle of territoriality applies to patents and also other intellectual property rights. A patent is valid in those countries for which the patent was granted. So the fact that a patent on a specific technology was granted for France does not mean that it will prevent your commercial actions based on the technology in Italy. Yeah? So the fact that a patent was granted for France means that there is patent protection possibly in France, but not necessarily elsewhere. Yeah, that means that in Italy there may not be patent protection, but based on the legal title, it's limited to those countries for which it was granted, and is still valid. So patent exists for a limited period of time, in Europe up to 20 years as of the date of filing. And second condition, if the patent is still valid, and that means that the fees for maintenance are paid, it's not rendered invalid. And it's very important, if you see a patent, that you really make sure that the patent is still valid before you draw conclusions from the situation. Patents are limited to commercial activities. There are some exceptions and limitations apply, also very important. So private use is exempted from patent protection. So is research on the protected technology. Okay, so this is an example of an intellectual property right that may be very important in your own area. Intellectual properties, I mentioned it, help to secure your intellectual assets and are a very important ingredient to be successfully on the market. You need to develop an informed strategy regarding which intellectual property rights should have. It should be based on the markets you would like to address, so geographical scope of your activities and other aspects as well. And the intellectual property strategy, so which intellectual property rights you need at which stage for which purpose, will support your business strategy. It's not a value in itself, it supports your business strategy, which means how do you want to commercialize something. And there are two options basically. You may use intellectual property rights on your own because you would like to commercialize your products and services yourself, or alternative is that the intellectual property rights may be used by others. So others may use your intellectual assets for which there are intellectual property rights that secure these assets. And there are two options here. If someone else is supposed to use them, first you can transfer your rights, for example, by selling it and transferring it, for example, to a spin-off company, or second, to offer a license, to enter into a license agreement, and that will be the main focus of the event today. Yeah, what is a license? Essentially, we have two parties. The IP owner, the licensor, the so-called licensor from a legal point of view, and someone who wants the license, licensee, for example, in another company or spin-off. And the license now has two aspects. First, it grants the permission to the licensee to use the intellectual asset. And in return, that's at least typical, there will be compensating means. So the licensee will pay royalties based on many different models you can choose in order to define how this return will be paid. The basis is a license agreement, which specifies the terms under which the licensee can use the intellectual asset of the licensor, for example, a technology protected by an intellectual property right such as a patent. And also very important is that with a license, the licensor remains the owner of the intellectual asset. There are different kinds of licenses. First of all, you can license out by, and that's the case I just described, by granting permission to use the intellectual asset and granting the permission to someone else. Main motivation is to create a revenue and to leverage unused or underutilized intellectual assets in your portfolio. can also have the opposite direction. So if you take the perspective of a licensee, you as a company, for example, as a startup, would like to acquire the right to use intellectual assets of other parties, for example, because you would like to get quickly access to external technology or other intellectual assets to save time, in many cases also to save money, because developing things on your own can be very time consuming and also very costly. And then there are mixed forms of cross-licensing, allowing between the two parties entering into a license agreement, establishing mutual permission to use intellectual assets of the other side. That helps to facilitate collaboration between the different parties and in the end mitigates the risk of infringement. Cross-licensing can have different extent. It can go so far as to giving access to pools of intellectual assets and intellectual property rights. At a later stage, in one of our presentations, we will go into details regarding further motivations to enter into licensing, to help you see in which situation in your everyday life licenses may be a very valuable option. Yeah, that brings me already to the end of the brief introduction to licensing. It's a teaser. We hope that you can see now better the context in which licenses really matter. And I would like to hand over back to, I think, Michele or Tom.
Thank you, Christian. You get me. So super. A question. Does anyone from the audience have any questions yet? So if you do, please feel to put them in the chat. Until then, Christian, I have a question for you. Is how can I know if a technology is licensed? Is there some kind of register of patents and or IP licenses available to look at?
Unfortunately, the situation differs from legislation to legislation. So in some countries, it's obligatory. In most of the countries, it's not. Information on licenses, including, for example, the willingness to license, is recorded if a competent office, so for example, a patent office, is informed about it. But as in most of the cases, in most of the legislation, this information is not mandatory information. Many patent owners and licensees do not report this kind of information, so the information is unfortunately a little scarce. So from a competitor point of view, what you would like to see a complete set of information on licenses already granted, licenses accepted, and by whom does not exist at the moment. So it's incomplete, unfortunately.
Okay, thank you. And I have a question just come in from the audience. So is licensing only possible with a granted patent?
No. You can also establish license agreements with unregistered rights, for example, trade secret information, confidential information. But of course, it helps a lot if basically it's based on an intellectual property right, which can be proved and also can be enforced.
Super, thank you. And can we maybe license just part of a patent? Is that also a possibility?
To my knowledge, yes. Yeah. I mean, because a patent can cover different inventions. So formally speaking, a different set of technologies can be protected by a patent, and you can also then just limit it to part of it, to part of the intellectual asset that is protected by a patent.
Super, thank you. I think we have time for one more question. Is it possible to license one technology to more than one person, or to have different industries on the same license?
Yeah. There's the freedom to establish license contracts. So for example, you can establish different license contracts for different geographical regions. You can give licenses to more than one party. You can also establish the provision that basically the holder of the intellectual property right does not use the technology. So there's a large variety of options that you can use in order to tailor the license agreement to your own needs on the part of the licensee, but also on the part of the license. So there are different commercial business models that can be covered by the appropriate license agreement.
Super. Thank you very much, Christian. I see we have a number of other questions coming in, but I'm just conscious of time. Christian, will hopefully be joining us at the end for the general Q&A session. So please keep your questions coming in, and we'll collect them all for the end. So thank you, Christian. I'd now like to pass over to the next session with Bowman Hayden and Adela Dvorkova. Bowman is from the Centre for Intellectual Property, and Adela is from the European Innovation Council. Unfortunately, Bowman was unable to be with us today, so we have a pre-recorded video for you to watch now.
Well, welcome everyone. My name is Bowman Hayden. I'm the director of the Center for Intellectual Property. And today I'm going to go through a brief presentation on licensing-based business models. I have a little bit of a cold today, so if I have to take a drink once in a while, I hope you bear with me. Thank you. Because in the knowledge economy, or maybe more importantly, the digital economy that we talk about nowadays, both digital assets such as data and software, as well as knowledge in the form of technology and brands and design, they all share one thing in common. They're all intangible assets that are non-rival. And by being non-rival, that means that there's an immense opportunity to leverage this knowledge out into the world, because everyone can have it at the same time. We can only have one person drive a car at the same time, but we can have many people have intellectual assets at the same time, just like everyone can have a copy of the same song. The problem, though, even though we can leverage this very well, the problem comes when this leveraging is done by others without any authorization. So in order to create business in an orderly fashion, it's very, very important to be able to use licensing as a business model to manage the business of dealing with brands, software, and technology, as we will discuss today. So I'm going to do a little bit on branding, a little bit on software, and talk a bit about technology, and talk a little bit more about technology and patent licensing. So let's go forward. We all know that brands are extremely important in the economy. We all know that having a brand on your product or your service is incredibly important. But oftentimes we mainly focus on having the brand on our own product and our own service, and don't think about how to use brands as a way to transfer, as a way of a commercial transfer. But there's many different models that can be used here. So we have brand licensing. For example, when we look at Philips, excuse me, when we look at Philips, you can have televisions that are made by other actors, but still share the brand. And then when we look at franchising, we can have Coca-Cola, for example, that can make its own beverages under the Coca-Cola brand, but then also have Coca-Cola be licensed out to other bottlers. Excuse me. In this way, Coca-Cola can leverage its brand and its business to many different actors across many different geographies without necessarily having to do all the work itself. And the last model here is merchandising, which Star Wars uses quite prolifically. You'll see the Star Wars brand on all kinds of different types of material, and in this case, you see their co-branding with Lego. Now, Star Wars also benefits from Lego, but I think Lego benefits a bit more from Star Wars in this relationship. Now let's move on to software and copyright licensing. Anytime you have an artistic work or software, digital photo, some type of music, digital music, there'll be some authors or some artists that produce the music, or that create the music, that's usually given to a producer, then to a distributor, then to a retailer, and then to the customer. But the customer, every time that the music is in digital form, or if the software, obviously in digital form, is the user has to enter into an end user license agreement to define how the user will behave. This is what we call a B2C license. So the user basically doesn't own this picture or music or software. They have a right to use it under certain terms. And nowadays we don't do this through physical products. We do this through the cloud, as everyone's aware. But still, the principles are the same. When I was young, for those of my age, we would buy software in a physical container. We'd open it up. We'd have a disk. You would own the disk, but not the software. The software could be used under certain terms, and this is the terms of the end user license agreement, which regulates the customer behavior. Nowadays, people click when they download an app onto the end user license agreement. We call this, the original one we called shrink wrap, when you ripped off the plastic cover and you entered into this agreement. Nowadays, we call it click wrap because we clicked on it and now we enter into the agreement. And we see that this way of thinking with copyright, this copyright perspective, also moves over into technology in certain areas where the technology itself is replicating. For example, when it comes to seeds, when you buy seeds that have been genetically modified, when you produce the crops, then the crops can, of course, produce new seeds, and those seeds can then be planted again. So there needs to be a license to regulate the behavior when something can be propagated. And we see the same thing, excuse me. We see the same thing when we talk about these oncomice. When you buy the oncomice, you also can, because they can be replicated, as you know, they also need to have a end user license agreement, and we call this mouse wrap. Now let's move on to the technology and patent licensing. As I say, all models are wrong and some are useful. So hopefully this one will be useful. Thomas Boreuter and I put this together a few years ago, and it's just to help people to get a basic understanding of the different models that are possible when thinking about licensing. If you look at the upper left side of the model, we talk about licensing in or licensing for access. And when we look in the bottom right, we look about licensing for revenue. This is about licensing out. So the first model is access to technology. Here, the development partner is licensing out, and therefore the technology-based business is licensing in a technology that it needs access to, that it likely would be more costly to develop itself. This is typically the arrangement, such as in Blue Break, where the technology transfer from a university is done through a license arrangement to a small firm. In the second model B, we talk more about working with competitors in freedom to operate. This is still licensing in, but mostly to have access to a technology so that you don't infringe on someone's intellectual property rights in relation to a technology that's used in your product that you already understand the technology, but you don't have the rights to use. When it comes to C, this is licensing versus production. This is a vertical commercial relationship. This is the typical relationship that actors have when they're deciding, instead of producing the product or the service itself, instead to license to another actor that will take it forward. So this is a classic example when biotech licenses to big pharma, and in the case here, the OncoCure case is a good example as well. And Adela will go through that briefly in a few minutes. And the last model is a complementary licensing. This is where an actor is creating its own products and services, but it would like to license in other fields of use or in other geographies to generate extra value from its technology to take advantage of this non-rival nature that we discussed. Oxeon is a great example of this, and I'll discuss that briefly next. So most of the time, we think of technology as a portfolio of patents or inventions, but also we can think of our technology as a portfolio of opportunities. So in the case of Oxion, their technology was used in multiple ways. So from a product sales perspective, doing their own sales, they worked in multiple industries. So they used their unique um, textile technology with the different fibers and tapes to use in areas such as sports, excuse me, in areas such as sports and in industrial areas as well as aerospace. In fact, they were even on the Mars rover, the recent Mars rover, with the wings. But they also used technology licensing by field of use. So they were able to license out their manufacturing process to make extra value. And this was used early in their development process to help fund the venture to move to the second phase of their efforts. So here's a great example of this complementary licensing strategy. Now I'd like to hand it over to Adela to take it further.
Well, thanks a lot, Bo. Good afternoon also from my side. My name is Adela Dvořáková and I'm a project advisor at EIC Transition. And I will present to you a little bit more in detail the case of OncoCure that Bo already mentioned in his presentation. So OncoCure is an Austrian biotech company that is active in the field of cancer treatment. So before we dive into the IP topics, I would like to present to you briefly the technology that OncoCure has actually developed so that you can better understand the other aspects that we will be discussing later on. So the technology developed by OncoCure is called specific total immune remodulation. It's a platform technology. What does it mean? It means that basically you can develop different types of products on the basis of that technology. In the picture, you can see a kind of schematic representation of a composition of a product that is developed based on, or that can be developed based on the platform technology. You can see on the left side the module 1, which OncoCure calls the warhead. The module 1 is normally connected to the module 2, which is an immunogen. And the function of the warhead is basically to deliver the immunogen into specific cells of immune system to, let's say, allow the immunogen to cause the desired reaction there to treat the cancer. The module 1, the warhead, is generic, so it always stays the same. It doesn't change. But depending on the composition of the immunogen, you can basically develop different types of vaccines to treat different types of diseases. And not only cancer, actually, the technology can be used also for treatment of allergies. So it is actually very versatile. Okay, what is the IP strategy of OncoCure? Just very briefly. So OncoCure has secured a broad patent protection of the main elements of the warhead. So the core of the platform as such is protected by a broad patent portfolio. It also keeps some information secret, and it also files product patents for some of the products developed on the basis of the technology. What are the advantages of this model? It is that this basically allows OncoCure to multiply the pathways towards product commercialization. What does it mean? That means that they are actually developing one of the products by themselves. That's a vaccine to treat breast cancer. But they also license out the IP to the platform to other companies, and the other companies are in parallel working on development of other vaccines to treat other diseases. So it basically increases the chances that one of the products or more of them will finally enter the market. Another great advantage of this is that OncoCure can actually secure revenues from licenses, from licensing, and use these revenues to finance its own R&D. So their own R&D is actually to a large percentage financed by the licensing revenues, and that in a situation when actually no product is on the market yet at this moment. And another great advantage is that it actually allows to save patenting costs, because in such a situation you can require your licensees to pay a certain portion of the patenting costs. So it also is a cost-saving strategy. Here, just briefly, that you have an overview of the patent portfolio of OncoCure. So OncoCure has 3 main patent families on the warhead. From now on, we will call them platform patents. And it also, to the date of drafting of the case study, it also had 2 product patents, one for treatment of breast cancer and one for gastrointestinal cancer. OncoCure generally gives 3 types of licenses. The first one is the by far most common one, and it's a target-by-target platform license. So it's a license that gives to the licensees the right to use the IP to the platform for a specific use case. So each of the licensees has its own specific, narrowly defined field of activity in which it can actually use the platform. OncoCure can also give licenses to complete products, and it can also give non-commercial research licenses, which could have the advantage that, for example, if the licensee comes up with some improvements of the core technology, OncoCure can benefit from those improvements. The licenses are generally exclusive worldwide, and they are limited to a very specific, narrowly defined use case, so that the licensees basically are not competing with each other. Now on this slide, we see the business and licensing structure. It might seem a little bit complex, but I will guide you through this diagram so that you can better understand it. So in the middle, you can see 3 black boxes. Those are 3 companies that are to a certain extent interlinked between themselves. We see on the left side Target Therapeutics. In the middle, there is OncoCure. These 2 companies actually have the same co-founders. The reason why they are established as separate entities is that Target Therapeutics is active in the field of allergies, while OncoCure is active in the cancer field. And on the right side, we see TYG Oncology, in which OncoCure actually has a little share as well. Now, the arrows between the companies represent licensing agreements. So between Target and OncoCure, we see 2 arrows. And that's because Target Therapeutics is the owner of the platform patent number 1 and 2, and OncoCure is the owner of the platform patent number 3. So the first thing that these companies have to do in order to be allowed to do anything is to grant each other freedom to operate. So we see 1 license from Target to OncoCure, and that's the license for patents, for platform patents 1 and 2 for use in oncology. And the arrow that is going back to Target is a back license that OncoCure is giving to Target on the platform patent number 3. And like this, both of these companies can actually use all the 3 patents in their field of activity. The 2 arrows pointing downwards from Target Therapeutics are licenses to all 3 platform patents. One of them is for the use in allergies for the company Allergopharma. So you see actually that Target is not developing any product by itself, but it's licensing out to someone else who is actually developing the product. And the second arrow is to Angotera. This is a license for veterinary use. From OncoCure, there is an arrow pointing downwards to an undisclosed company, so we don't know which company that is. And that company is also developing a certain product that is intended for use in cancer treatment. And from OncoCure towards the right side, we see an arrow to TYG Oncology, and that is the license for use in gastrointestinal cancer. And TYG Oncology is further licensing these patents to Apollomic Inc., on whom they are relying for the clinical trials. So you see that this is a kind of a little bit of complex structure that they have put in place, and that the platform allows them to create. We have agreed with Bo that that would be most likely the business model C that Bo just presented. So basically you see OncoCure is prioritizing licensing over its own production. which, as Bo also rightly stated, is quite a common practice in biotech, because OncoCure is a small company that has, of course, a lot of knowledge and all the IP and everything related to the technology, but it might not have the all the skills and the experience necessary to actually bring the product to the market. So at some point, they will always actually prioritize licensing over own production. Under OncoCure in the black box, you can also see there is the product OQR200. That's the only product that they are still developing by themselves. That's a vaccine for breast cancer, but it's likely that at some point there will also be a licensing deal to a bigger company to actually bring the product to the market. And finally, briefly about some licensing provisions that we would like to highlight in this case study. I will not go too much into detail of that because that will be the topic of Karin's presentation. But I think it's also interesting to highlight some good practice that we have observed in the company OncoCure. So the licensing agreements are generally not limited only to patents, but they include also secret know-how, so trade secrets, and also support for manufacturing. Why is this advantageous? Well, that's because when you license out to someone to develop your product and bring it to the market, well, you basically share the same objective. You both want the product to enter the market and be successful and bring revenues, and therefore you want to give your licensee as much support as possible so that they can effectively use the technology and don't have any issues and don't have to, let's say, reinvent the wheel. So you want to give them as much information and support as possible, so that actually it kind of is easier for them to work with that technology. They also include back license on improvement of the warhead. That's actually a very interesting thing. What does it mean? You can imagine all the licensees and also OncoCure as users of the same platform. And each of them is working, let's say, more or less separately in their own field, but they are working with the same technology and they are developing something on the basis of that. And it's likely that in the course of the development, they might come up with some improvements on the core technology. And the back license gives all the licensees and also OncoCure the right to use these improvements in case that that anybody comes up with something that makes maybe the warhead a little bit more efficient, more, I don't know, cost effective or anything. These licenses are granted on a worldwide, free and non-exclusive basis, and of course in non-competing fields. One of the advantages that actually OncoCure mentioned in this respect is that this is also a very helpful tool in negotiations. So licensees are actually interested in having these kind of provisions in the licensing agreements. And for the licensor, it's also a great thing because it allows you to kind of continuously increase the value of your technology. Another interesting licensing provision that I already touched upon is that the patent costs that are relevant for licensees are borne by the licensees. That is important, especially when you are still a company that doesn't have any revenues from product sales, because it mitigates the risks that you will be basically sitting only on the costs while having no relevant revenues. So it's something also to always consider, that a fair portion of the patenting costs should be borne by the licensees. And finally, the payment structure that is foreseen in the licensing agreement basically foresees that there might be different kinds of scenarios in the future. Usually when you set up a licensing agreement, you think about the best case, but it's not always the case that everything works out as planned. And for that reason, it's always good to have a diversified payment structure so that you can secure some revenues in all kinds of scenarios. So the agreements include an upfront payment. There are also some milestone-based payments, and there is also an anti-shelving fee foreseen. We will hear actually quite a lot about the anti-shelving fee because that's a very important provision. Just briefly here, what does it mean? It means that what we want to achieve is that your licensee brings the technology to the market, that he kind of doesn't put the technology on the shelf, and an anti-shelving fee allows you to collect some kind of minimum revenue, minimum royalties, in case that the technology actually is not brought to the market within the specified time frame. Okay, so that would be all about OncoCure for this moment. If you would like to read the whole case study, you can go to epo.org/case-studies. So the full case study is available there for reading. There is also a podcast related to it, and there are also other case studies of a similar kind. So in case you are interested to read a little bit more, don't hesitate to visit epo.org/case-studies. I'm looking at the clock and I see that we still have a few minutes left. So I suggest that Bo comes back to me. We can unshare the presentation. And I would have actually a few questions to ask Bo. Maybe we could have a little discussion together to a little bit broaden the perspective on the topic, broaden the view, and also kind of set the scene for the presentation of Karin that is going to come now about the practical aspects of licensing agreements. So what do you think, Bo? Is it fine with you?
Sure, let's have a little chat, Adela.
Perfect. So my first question would be, Bo, you have presented all those different business models that you can build based on licensing. And then I presented this specific case of OncoCure. And when we were preparing for this session together, we had actually a little discussion about whether this is the licensing model C or maybe a blend between C and D. And one could have actually long discussions about that. And it might sound a little bit theoretical. So what would be the practical usefulness of this? Like, why would it be practical for a company to think like that, to think about the different models and think about, do I want to fit in the model C or D? Do I want to have this or that? So what is the practical use of this model?
Well, even though that I'm an academic, I would advise people not to get too stuck in the models. So the models are just there to give you a bit of inspiration, maybe categorize some ways of thinking. Certainly you can do hybrids between these. You can do multiple ones, right? When we spoke about OncoCure, what is the difference between C and D? Typically the technology licensing model or the vertical model is one where a company is mainly doing their own production or service, and then they find extra value. Or sorry, the C is when instead of doing their own production and services, they license the whole technology out for others to take it forward. They kind of hand it over and let other people do it. Whereas in D, they're doing their own products and services themselves, but find extra value in the non-rival nature of their technology to give to other people in specific uses and in geographies. So one is more of a main business model where, like most biotech firms, are not going to vertically integrate and become full-fledged pharma companies. So they should think about this right from the very beginning. I think they're all thinking about this. And of course, an extension of licensing in their case is for their whole company to be bought, right? That's just the next step from licensing where the other company takes all the assets over. So it's just to think, is this going to be the main model that we're going to do, or is it going to be an extra model in order to leverage as much value out of our technology as possible? Does that make sense?
That makes perfect sense indeed. Well, that brings me to another question, because basically, when we think about these different models, I would imagine that that the value for our audience in this is basically that you give them a kind of structure. They know what options they have, and they can actually decide at some point what they actually want to do. Right? Before you do anything, you have to know what you want to do. When would be the right time to start thinking about that? So before you answer my question, I will just give you a little bit of background about our audience today. We will have quite a or we have quite a diverse spectrum of participants today. We will have maybe some research groups that are working on some early stage technologies. We will have some young companies that are just in the development. We will have maybe some companies that already have the first products on the market, or they are now preparing for the launch. So what would you recommend? Like, what would be the right time to start thinking about the different business models?
Yeah, that's a good question. I think what I always try to recommend, especially for small companies that are just starting or research projects, is that the amount that they need to get a handle on what are all of their important intellectual assets or technology assets. What do they have in total that's valuable? And by that, it's a little bit like throwing the Legos out on the table. From there, you have a good idea of what you can build, right? So there you should have professionals come in to help you to think about intellectual property rights, but just to get a basic understanding of all the different technology assets that you have, that, as I mentioned, are portfolios of opportunities, right?
Mhm.
And by looking at this, then you can start to think, okay, what types of business models could I do and which ones make sense? Some of them can be done in parallel. You know, you can license to two different actors in fields of use, but not the same field of use. Sometimes you might slice off something to help you get going that's not part of your main business, as in Oxyon, and then move into more of a product sales thinking. All these types of things become more easy to talk about once you understand what is it that you have as technology assets, and also understand what is the competitive environment that you're entering into.
So when would be the right time to think about it? As early as possible?
I think that, well, most people have an intuition of a business model, I think, when they get going. But I think the best thing to do is to really understand the nature of what technology they have and what models are possible. So you want to decide not to license because you thought about it, not because you didn't know about it. So I would say the sooner the better, so that you have it as part of a plan.
Mhm. You also mentioned that it is important to get the IP advice and expertise. Would you maybe be able to tell our audience where to look for the IP expertise? So let's say, imagine I'm a young company, or I'm starting a young company. After this training, I will know that IP is very important, but maybe I'm not an IP expert, so I don't really know exactly what to do still. So where can I go to get IP advice? Should I get a lawyer? Should I go to a patent attorney? Should I find a specialized consultant? So where to go?
I think this is one of the issues that I've spoken a lot about. I'm sure you've heard me, Adela, talk about this. I believe that, you know, especially small firms, they need this type of meta consultant because they have a lot of issues, right? You know, they probably heard that they should get a patent, so maybe they would go to a patent attorney, but maybe they have software that they would like to um, or participate in open source in some way, or maybe they would like to keep things, it's better to keep things secret. So what you would want is someone that could help you to understand what types of intellectual or intangible assets you have and how that relates to your business, what business models are possible, and then based on that, what type of IP strategy you need. I always say that the IP strategy is more important than the IP rights, especially in the beginning. Sometimes it's hard to find that one person that can do all those things, but so you might have to bring in different people. You should try to find someone as more holistic as possible. But definitely, if you're doing licensing, you need a lawyer to help you out. And I should have a caveat that I'm not a lawyer, so I'm giving advice as a business person today.
Okay, very good. Another thing that comes to my mind is so when you imagine that you are just considering entering into a licensing relationship with a potential licensee, what would be the main considerations for the beginning? What do you have to think about before actually closing a licensing agreement or choosing a potential licensee?
Yeah, well, of course, first and foremost, you want to try to choose someone who's likely to be able to achieve the goals that you have in mind. You talked about the shelving issue. You know, when you license to someone, you're not going to make any money unless they make money, right? Your idea is not going to get out in the world unless they take it further. So you want to find someone who you think is going to be dedicated to doing that. And then, of course, you want to give that person all the information they need, but no more than what they need, because maybe um, you can use their intellectual assets and other purposes for other actors. And also, you don't necessarily want to give too much to the other side, because you have to be careful, and they have to be a trusted actor, because once you give them things that are, say, secrets, now they're responsible for your secrets, which is always tricky, right? So I think this trust that they will handle your assets properly and that they will, work hard to commercialize in this collaboration is critical.
Mhm. That actually brings me to the topic of the object of the license. So what you should be actually licensing out. So I touched upon it also a little bit in the case study of OncoCure. I said that they combine the patents with the trade secrets. They include also some support for manufacturing. So the first question would be actually just that our audience can imagine that a little bit better. What does it mean to combine patents with trade secrets? How can we imagine that? Because one can say when you file for a patent on your technology, you should disclose your technology sufficiently so that it can be reproducible. So how can you actually combine it with trade secrets? Could you maybe give us an example of that?
Yeah, so typically, oftentimes in licensing, we think about two types of licenses. One's a technology license and one's a patent license. If it's a patent license, typically the person that you're licensing to already knows the technology. They just need to have a permit to be able to use it, or for you not to block them. So then the license object would mostly be the patent that covers the technology. That would be the main discussion. But if it's a technology license, in other words, the person you're licensing to needs knowledge and know-how from your group to help them implement your technology, then that could be things that aren't patented. It could be things that are kept as trade secrets. And well, you probably would argue that everything that's not in the patent that's valuable, you're trying to keep secret. Now, whether you manage them as a trade secret, that's another legal issue to think about. But now you're actually transferring more knowledge than what's in the patent to an actor that probably needs this knowledge to understand how to proceed. This could even include having people from your staff participating in teaching and working with the licensee for many months or a year or years.
Mhm. Okay. So it's clear that one of the advantages of this approach is that you are basically giving your licensee even more support and increasing the chances that he will be successful in reaching the goals. Can you think of other advantages that it might have to combine patents and trade secrets? Would it be,
Yes,
for example, yeah, go ahead.
no, I was going to say, one other issue could be that when you have relationships connected to trade secrets or know-how, this can extend longer than the period of a patent. And also, if the patent for some reason is invalidated, then you still have other objects in the agreement that allow the agreement to continue. So it can create more security around the control position that you have for your intellectual assets that you're licensing than just the patent, which could be vulnerable and, as you know, expires over time.
That's exactly what I had in mind, actually. So when you imagine this scenario that we have a licensing agreement in place, the patents have expired, but the license still continues for the trade secrets. From your experience, do you think that the license would typically continue with the same or under the same conditions, or would the licensor maybe have to settle for lower royalties, or would the terms then change in the licensing agreement?
Yeah, it would likely have to change because now the strength of the objects that were transferred is lower than it was before. You know, if you just transfer secrets or know-how, the people that you transfer to are going to put an investment into that, and their investment is not being controlled as well as it would be if there was also a patent. So there's more risk involved, which means that you're going to have to share that risk probably in a different way than you had originally in the agreement.
Mm-hmm. And what can go wrong in this case? So when we imagine such a situation, and let's imagine that the licensee discloses my trade secrets. So what can I do in such a situation? How can I protect myself or defend myself?
Yeah, so this is really a legal question, but just from a business perspective, when you trust people with trade secrets, you really are becoming vulnerable in that way, right? So by letting them have the secrets, you are now no longer in charge of something that once it gets out into the world, it's out into the world, right? So it's possible that if you give somebody information, a secret, and it gets out into the world, that there's, even though you might have some type of agreement about what happens in that case, it might be that there's no type of compensation that will put the cat back in the bag, so to speak, right? There's no way to, it's bad to talk about putting cats in the bag. I don't know why we would do that, but there's, sometimes when secrets get out, they can destroy the whole business. And while there could be certain legal clauses about how to handle that, that's not what you wanted to accomplish. So now you've extended your secrets to a group of other people, and secrets by their very nature are difficult to contain.
Mm-hmm. And if I disclose my trade secrets to my licensee, and then the licensee discloses them to general public, can I prevent the general public from using those trade secrets because they were my trade secrets?
Yeah, this would probably be the better question for the lawyers that are coming up, because it'll probably depend a bit on jurisdictions, and I know they've changed the trade secret laws recently in many places. Once something is out, it's hard to prevent people from using it, and definitely it'll definitely be used as prior art in relation to other things going forward. Depending on how the negligence of an actor relates to others being able to use it, I think I'm going to ask you to talk to the lawyers about that, because it might be different in different jurisdictions. Excuse me, jurisdictions.
Okay, thanks a lot. So
You're always
let's get
trying to
back
get me to be a lawyer. You're trying to get me to be a lawyer, aren't you, Adela?
I wanted to say let's go back to the business questions again. Maybe one last question. We were also touching upon exclusive and non-exclusive licensing in this session. So how do you decide whether you grant an exclusive or non-exclusive license? And maybe you can approach this question a little bit from a broader perspective, because you also talked about licensing brands, software. So how do you make the decision whether exclusive or non-exclusive?
Yeah, so that's a good question. Oftentimes, it depends on what the licensee requires in order to be able to effectively succeed in their task. So when it comes to biotech, for example, it might not be very easy to offer a general non-exclusive license, because that won't give enough exclusivity to defend the investment that they'll need to make, to take it forward. So you might have to make it exclusive in order to give people enough control to put in the investment that's required. Non-exclusive would be something where maybe you give it to everyone in the whole industry, that moves everyone up to a similar level, or maybe not a lot of investment is required by any one actor, and no one is looking to have exclusivity themselves in the market. Certainly, non-exclusive licenses are what's used when it comes to copyright, because everybody can have it at the same time, right? One thing to think about instead of non-exclusive, because that seems very broad, is to think about a portfolio of exclusive licenses. So exclusive for this use, exclusive for this geography. So it's something in between a purely all-in exclusive license and a non-exclusive. It's exclusive for specific areas. That's probably a better way to think about licensing when it comes to technology and patents.
Mm-hmm. That's what we have actually seen in the case of OncoCure, right?
Right, exactly.
Okay, I'm looking at the clock. I think that our time is up, Bo. So thanks a lot for this. I think this was a very insightful session. I'm sure that our audience will learn a lot from your experience. So thank you very much for your time.
Thanks, and thanks, Adela. It's always nice to see you, and thanks for bearing with me with my throat today. Sorry about that.
No problem, Bo. And Tom, I'm giving the word back to you.
I'd now like to have a question and answer session on the video. As I mentioned, Bowman wasn't able to join us today, but my colleague Thomas Breiter from the EPO, who also was actually part of the team who worked on that initial paper, is joining me, and also Adela is on stage as well. So without further ado, I'd like to ask some questions. Adela, the first one for you, it came in from the audience. So OncoQR back licensing is agreed in non-competing fields. And can you elaborate on this a bit more, please? How is the potential competition evaluated?
Mm-hmm. Yeah, that's a good question. Well, basically, the non-competing nature is actually by default, because as I explained in the presentation, each of the licensees has in the license specified a very narrow field in which they can use the technology. And also the back license actually is only for this narrow field. So already when the licenses are agreed upon, it is made sure that that each of the licensees will have its own narrow field, that those fields of course will not overlap. So each of the licensees is actually developing a product for a specific disease, and that's always a different disease. And yeah, so also as a consequence, the back licenses are automatically actually granted for non-competing fields. Does it make sense?
Yes, super. Thank you very much. And I have a question for Thomas has come in. So could you expand on the idea that an IP strategy is more important than just holding IP rights? Is not having a strong patent sufficient?
Thank you for the question, and that builds upon what Bowman already said. I'm sure that Bo was already thinking about a strong formulation to be remembered, and we can adjust a famous saying of Peter Drucker and say IP strategy eats IP rights for breakfast. So what does it mean? Actually, it's not the one or the other. It's about priority setting, to have your priorities put right. And it is clear that only owning the patents, piling up a lot of IP does not create value. It only creates value if you have an articulated, implemented IP strategy, because it's about how do you advance, how do you manage, how do you leverage, and finally enforce those rights. That creates the value. So to come with an example from practice, from do-it-yourself practice, if you have a hammer, might be a great hammer. You can do a lot with the hammer, but if you try to nail screws, it will not work. But if you have in comparison bad tools, you have a Swiss knife with many functions and so on, and none of the tools is really great, but it is ready at hand when you need it, and you know how to use it, then you can achieve astonishing things. And that's the same with IP rights. If you have a strong patent combined with trade secrets, as we talked about, different IP forms, and you combine it right and you apply it in a smart way to support your business case, then you are on the right track, and then you can succeed. Does that answer the question?
I think so, yes. Thank you very much.
Thank you.
And a question for Adela. So is it realistic to drive significant progress in vaccine development, mainly through licensing technology, as demonstrated by OncoQR?
Well, it depends on how we understand this question. So if we talk only about if we talk about the technology development, then for sure, yes, it is possible to license out pretty early on and then basically rely on licensing for the rest of the development until the product reaches the market. If the question is referring to financing, which is, I assume, the case, because that's what we were also talking about in the case study, then I would say, I mean, the answer is not that easy in this case, but I would say rather not. I would not recommend that. So in case of OncoCure, they actually achieved to finance approximately 75% of all preclinical trials from licensing revenues, which is actually quite a lot. So that's a big success. But we are only talking about preclinical trials. When it then comes to the clinical trials, it gets much more complicated, much more costly, and there I would rather say it's not realistic. And at some point, it's advisable to engage an investor and get significant extra revenues from or financing from other resources. So I would not recommend anybody to try to bootstrap vaccine development.
But just to add to that, I think it has a high value for the company if the company early on can prove that they can create revenues. So every investor, every funding agency, everyone will trust more in the capabilities of the technology and the company if they can create revenues that are relevant, that are significant, and then leverage those with the investors' money. And it is easier than to get the additional funding required to get those that support implemented if you have your own revenues. That means you keep control over the financing. And that means you keep control over the business. And therefore, it is strategically important to create early on revenues by, for example, licensing part of the technology.
It's a good point, yeah.
Actually, related to that, we've had a question come in really talking about sort of what's the most relevant. Do you actually want to be building a license around your sort of your target or around the sort of the core patent that's behind the technology? Or is there a preference for how you base it?
So for me, the question was not completely clear. Can you rephrase the question?
Yes. So if you mentioned stuff that licensing is on a target, so you're licensing this thing, but also you can mention that you're licensing the patent. Which one is more relevant in the deal?
Yeah, so I think that connects well to what Bowman said before, that it strongly depends on the needs of your partner. So at the end of the day, when you license, you want to have a good partnership established. And that means that there must be a win-win relationship. So that is what counts. And for that reason, you want to understand the business case of your partner and then give him the rights that he needs. And if it's only about the patent rights, about the freedom to operate, then it's more about the patent licensing. And if it is about enabling, then it is for sure the other aspect that you want to have the targets and the technology license.
Super, thank you. Actually, quite a lot of questions still for this one. So maybe one for you, Adela. Can both spin-off and licensing options be pursued simultaneously? And what should be kept in mind?
I would actually play this question in the field of Thomas, because Thomas actually, before joining the EPO, was a director of a technology exploitation office. So I think that he's actually the better person to answer this question. So Thomas, what is your view on that question?
I'm sorry, I also had now a technical interruption. Tom, quickly rephrase the question. Sorry.
So So can both spin-off and licensing options be pursued simultaneously? And what should you keep in mind if you're taking this strategy?
Yeah, absolutely. So it is. It of course depends strongly on the business case and the technology, but many technologies coming from universities and coming from basic research are platform technologies, and you have multiple options to commercialize those. And there it is of high value or of strategic value if you are able to focus, that you focus on one application and do that pretty well and be successful in that. While you focus on the one, you cannot deal with the other options. And that means in your business, you could have a spin-off where you have one application or one market targeted, and for the other markets, you license out the technology so that you make best use of it in parallel, and you have synergistic effects. I see often the companies struggling with that, so because they think more sequential, so first you do the one, then you do the other. But please keep in mind that the patent gives you, or the technology that you have developed, that gives you a time advantage. And when it takes years for you to come to a certain application and to address the needs of the markets there, then maybe the opportunity is gone. Maybe the opportunity is there now. And if you have no resources to address that properly, then partner with others that have the resources and that can bring that in. And that is the strength of partnership and of licensing. So I think it's a very good approach to combine those approaches and also to be experimental, see what works well, and then choose the best options. Also be prepared to pivot, meaning that if the one option does not work, that you know about the other IP transactions that you can do, and that you are prepared to move ahead with the other options that are there. And I think it's good to have this thinking, spin-off, licensing. These are all different IP transaction modes that can help to succeed.
Super. Thank you, Thomas. We've had a couple of questions coming in about trade secrets. I think that's a little bit off topic for this session, but certainly Bowman mentioned it, but he's saying that really with a trade secret, once the idea is out there, it's actually quite difficult to stop people reproducing it. So I hope that sort of covers the trade secret questions in a sort of very broad brush. I think we've got time for one last final question. I know everyone needs a break, but we've got a good one here. I've read it for Thomas again. So sorry, Adela, you've had a bit of quiet time in this session, but really sort of that sort of negative side of what happens if it goes wrong. So what if the licensing agreement doesn't achieve the results you wanted? What actions could a company take?
Mm-hmm. Yeah, that's a very good one. That's a typical thing that negotiating a license agreement often is experienced by those that are rather new to it, like running a marathon. And you reach the goal, you are completely exhausted, and then for the next time you just want to relax and deal with other issues. So it's not the priority the next day to go for the next run. And that is a little bit what happens in practice, but it comes at a cost because the post-license agreement period, when you have signed the license agreement, then you should roll up the sleeves and make the agreement work. And it's often in the practice that people that have negotiated the license agreement are not those that implement it. So you need to follow up that everyone is aware what are the licensing regulations, what is meant to be achieved with it, and to have regular meetings and to work on that, so that it really gets implemented. The license fees are also paid. Studies show that a larger part of the license, the royalty calculations are wrong, so that over time it goes down. That is, for example, for the effect that you have a second or third version of the product, the further advancement of the products, that they are not flagged as being royalty-based products, and you calculate royalties out of that. Just some examples of that. It does not always work automatically that the license agreement is implemented. So that's one aspect. And the other aspect is that when you negotiate a license agreement, you make a prediction of the future, but you might have been wrong. And when you have been wrong and the arrangements were not right, then it might be that one of the partners does not have the corresponding incentive to go ahead with the commercialization of the products. And that might result in the situation that you have to renegotiate the agreement. And you need to be prepared for that, and you need to have the understanding that this might be required. I've seen many great license agreements failing because one of the two parties was not ready to renegotiate the contract. And it happens very often, and it's an important factor that you want to keep a win-win thinking in the relationship, that you're sitting in the same boat, and only if you both row in the same direction you can win, and therefore that is of utmost importance.
Super. Thank you very much, Thomas. I'm quite conscious of time, and I think everyone could maybe do a quick break. It's been quite an intensive hour and a half so far. So if we take a few-minute break, we're scheduled to start at 25:02, so that gives us a quick 7-minute break to go and have a leg stretch and grab another coffee. So thank you very much, everyone. Thank you, Thomas. Thank you, Della, and we'll see you all in 6 minutes as it is now. So enjoy your break.
Thank you. See you later.
Good afternoon, also from my side. I'm going to talk about license agreements and how to get there. Christian already explained the general concept of licensing, that somebody owning IP, the licensor, gives a third party, the licensee, access to IP and gets some financial and other compensations in return. Let's now look a bit closer at the motivations of the licensor and the licensee. Even when you're aware and you're always on one side, let's say as the IP owner, it's vital to understand the other side. It is a prerequisite for the negotiations. So we'll start with the licensor side. The opportunities of out-licensing were already explained by Bowman. And I want, therefore, to stress more the risks, to understand your own risks and the fear of the other side as well. So the risks on the side of the licensor is that he's creating future competition. As a licensor, you should be also aware that you need additional effort and cost to monitor the license. There is also a risk that the licensee doesn't follow the rules of the contract. So you will have additional efforts to deal with these issues, and non-acceptable activities of the licensee can also have negative effects on your own reputation as a company or on your own IP, let's say, for example, on trademarks. On the other side, we've heard the main reason for getting into a license for the licensee is saving development time and costs, and also the avoiding infringement of the licensor's IP. With regard to the risks, of course, if you fail to bring the product to the market, you will not get your issued payments back, so you will have the risk of sunk costs. In principle, you're bound by the terms of the contract of the whole duration, but like it was already explained by Thomas, there should be the openness on both sides to that you can ask to renegotiate the terms. In addition, it may happen in case of patent infringement that the licensor doesn't want to sue infringers because he fears the damage to the IP in case of a counterattack. So as a licensee or dependent on the licensor. But I want to take a step back, like Christian and Bowman were explaining, and have a look on the business side. Before we start preparing and negotiating, we need to imagine the deal. What kind of cake do we want to create? Thomas also mentioned it in the Q&A session. We have to think how to combine the strengths of both parties to achieve the best solution for the market. The bigger the cake gets, the bigger the slices are for both parties, which means we try to create synergies, and then it's easier to achieve a win-win situation. So we need to look at what we want to achieve and how we can get there. What ingredients do we need? What can we provide? And what do we need from the partner side? This, as I said, refers back to the business goals and to the business models presented by Bowman. You should be able to clearly define your business reasons and goals. And therefore, you should also identify for each IP asset what will be the benefit for potential licensees. Why is this specific IP able to contribute something to the goal? In addition, you should be careful and identify for each part of IP which you want to add to the deal that you have the right to license the respective IP, that you have ownership. For example, in Austria, you have to claim ownership of employee inventions, but also with regard to other IP like copyright, software, or design, due diligence is worthwhile. Here you will see some examples of questions to clarify your goals on the basis of your specific market, what you have to offer, what you want to obtain or avoid. In the next step, we have a closer look on how to find potential licensees. If you're actively searching for partners, you can use the services of patent brokers, of dedicated marketplaces and platforms, or enter relevant communities. There is a lot of valuable information available, for example, on the EPO HTB website. You will see the link on the top right corner. And another possibility for marketplace platforms is the platform of the Enterprise Europe Network. If you have identified the key players in your market, you can, on the one hand, it's important to evaluate them and to get information on their market power, expertise, where they are geographically active, about their size, of course, also financial due diligence, to be able to compare different partners. But remember the cake. You have to think on who's the best fit to your needs. And also on the other side, how can you with your IP add value to this partner? The next important step, imagine you have already contacted the most promising candidates and they've raised interest. How do you actually prepare the meetings with your potential partner? So it's moving on with the preparation. It's important to take a closer look on your expectations and define with regard to your goals the key points of negotiation and also the strategy. What is, in your point of view, the most important outcome, the best outcome, what are acceptable alternatives, fallback positions, what's the bottom line, and what do you want to avoid for all costs. And also to write down your expectations, but to have in mind also your BATNA. BATNA is not only a city in Algeria, it's also a synonym for the best alternative to a negotiated agreement. So if you stop the negotiations and leave the table, what's your alternative? And to this you should have in back of your mind. When you enter in negotiations with one potential licensee, you should prepare even a more detailed due diligence regarding this partner. The more you learn about the partner, the better you understand his reactions also during the negotiations. So it's really important to make assumptions on the expected positions of the other party. What will be their ideal position? What would you expect is their bottom line, their strategy, the business model, strengths, weaknesses of the other side? How important is it for the other party to get a deal? What can be challenges? And this information will help you to prepare counter arguments, to prepare suggestions, to accommodate your partner's needs without giving on your goals. And during the talks and during the negotiations, it's important to validate your assumptions and to ask and get additional information on the other side. We're coming closer and closer to the negotiation. So there are further preparatory steps. One has been already mentioned, the confidentiality agreement. So as soon as you start exchanging material, but the latest before you start negotiating, you should sign a confidentiality agreement called non-disclosure agreement, or if there is some exchange of material beforehand, also material transfer agreement. To apply for funds or grants, your partner may need some memorandum of understanding or letter of interest. So this might be offered or requested. Important for preparations of your own side is to wisely choose your team according to knowledge and negotiation skills, and of course also to make a preparatory meeting to inform all team members about the essence of your preparatory work and the informations you have gained about the other party and your negotiation strategy. It seems obvious, but it's surprisingly often neglected due to time constraint, but this internal alignment is very, very important before you enter the negotiations. And last point here is the time frame, that you set realistic time frames for the meetings or taking several meetings into account. When you start with the negotiations, it's a good practice not to start with a prepared contract, but to concentrate on the commercial key terms, and which should be covered by a kind of term sheet, so that you seek to agree on a very high level the commercial deal structure, and this allows you always to come back to this common ground. So at first, agree on the deal, on the commercial essence of the deal before later on you're putting this into the legal language at the end. Some general advisable tactics in negotiations is active listening, that you ask questions, try to find out more, that you communicate clearly and try to find out also the reasons behind the position of the other side. It's good practice to define the role of your team members, that you dedicate a person who is taking notes and also share the minutes, who offers to make the first draft. All these things have to be decided. But always keep in mind that no deal is better than a bad deal. So refer back to your preparations, also the bottom line, your BATNA, and consider to walk out if necessary. If you have agreed on the key terms, it's important for the drafting that you put it in legal language that both parties really understand. And some more technical tips is to check cross-references, make the agreement also visually attractive, and double check also all the details about IP registrations. In the next slides, I will walk you through the main commercial ingredients of a license. So the structure, which is more or less you will encounter in most of the license agreements. So of course, in the beginning, you have the contractual partners are mentioned, licensor and licensee, and also the purpose of the agreement, which also has an important function in some jurisdictions, so it shouldn't be left out. The next part of the license agreement is defines what the licensee gets. So it's the subject of the license. If it's patents, patent applications, which are licensed, know-how, trademarks, copyright, software, as already mentioned, there it can be a lot of different kind of IP, can be bound in one agreement or have separate agreements for different subjects, for different IP rights. And the definitions is also a very important part, which should clarify and avoid repetition throughout the contract, so that everybody knows what's meant by licensed products, for example. Bowman already mentioned some possibilities you have regarding the rights and restrictions, so that you can have an exclusive or non-exclusive license. You can decide on the type of activities, only for distribution, or a license also for use, for production. You can specify specific fields of use. This was also one main part in the case study presented by Adela, and also define different territories of the license. So if it's only for the US or for Europe or worldwide. The length of the license can correlate with, for example, the term of the patent, but it can be also longer, as mentioned in the discussion with Bowman and Adela, when you have some parts of the which are subject of the license, like know-how, which are also have a longer time frame. Regarding the termination, possible early termination. You can also foresee some regulations, as it can be important for the licensor to get out of the license agreement in case of an underperforming licensee. We will see one possibility later on, and it was also already mentioned by Adela, the anti-shelving provisions. And also for the licensee, if he finds out the technology lacks potential and it's not working out as he has envisioned in the beginning. So what possibilities are foreseen for earlier termination? What provisions would survive a termination, or what the consequences would be? That was the part of the licensee. And what gets the licensor? Financial compensation. I will detail this in a few seconds later on. Also auditing provisions. At what times and with what content does the licensor get a report, and also the right to inspect books or to audit if it's reported correctly. With the example of OnCure, we already mentioned grant backs and cross licenses are other possible compensations. How do you live with an agreement with regard to the existing IP? So rights and obligations regarding the IP is how do you decide between licensor and licensee on patent strategy, maintenance, choose of countries if the patent applications are still ongoing, who is bearing which costs in the area of patent cost. That was also mentioned at the case study before. And you have to decide how to deal with patent infringement and enforcement. Who's responsible? What's the procedure? Who bears the cost? How do you live the agreement later on with regard to other issues? So Bowman mentioned the technology license. So in this case, the licensee may need services from the licensor like training, know-how transfer, consulting, and you can already in the license agreement foresee specific conditions how a licensee can access these services from the licensor. How can the license be transferred, or can the license be transferred in case the licensee is acquired by another company? This should be looked at with assignability, but also the question of if the licensee is allowed to grant sub-licenses. In the context of a university, we have always very early stage technologies. So there is the question of improvements, very important. Both parties may have ideas for improvements, and it should be stated who owns these improvements. Are there any provisions to access the improvements of the other side, and under which conditions? There was also already one possibility explained with OncoCure. You can set specific performance criteria, anti-shelving provisions, when you state that the licensee has to use commercially reasonable efforts to exploit the IP, and this may also give you the possibility for an earlier termination if the licensee fails to use these efforts. And we will have in the later case studies also some more examples on that. As Thomas already mentioned, it's very important to live the agreement afterwards, after the signature date. I will come to some aspects of that as well. And so the governance, steering committee, license monitoring is also very important. There are some legal provisions. I will just mention the applicable law and jurisdiction because it stands at the end, but it has to be decided before you start drafting because it really changes the language of the license agreement. With regard to financial considerations, it's important to have this balance of interest. And I want to mention this different view of licensor who wants to get a return on investment. So he's concentrating on the reward. The licensee is concentrating on the risks accompanied with this collaboration. And so as licensor, as the more risk you take away from the licensee, the more you go and take over risk, the higher the more the licensee will be willing to give you a higher reward. I will explain that also here in the next slide with the financial elements. So you see on the one axis the time and on the other the amount of money. From the signature of the license agreement, the licensee starts producing. At the beginning, he has some cost, then he gets revenue, reaches break even, and hopefully will have a lot of more revenue. So you're structuring the financial elements. You have a down payment, usually at signature of the license agreement, but you can also split it if you have a very early technology in milestones payment. But the down payment is combined with sales-based license fees on the other side. And with these sales-based license fees, you as a licensor also get take over some risk, because if there is no sales, you don't get any reward. So that's the milestones payment can be split, where you always also take over some risk. There is the possibility to enter into option agreements beforehand with specified option fees. And with regard to anti-shelving, usually there you also agree on annual minimum license fees, which apply in any case, even if you don't have any sales. And this should avoid or should be an additional incentive for the licensee to put his best efforts into getting the product on the market. You will find these financial terms also listed here, with addition of sub-license fees in case they apply. With regard to model agreements, several years ago, when I was new to the field of licensing, I was asking a colleague of Fraunhofer if he has a model contract for licensing agreements. He answered, sure, he has hundreds of it. I hope after this presentation you understand why, because it's all tailor-made to the licensor and licensee. But nevertheless, there is some good resources available on, for example, the pages of the European IP Helpdesk. There is also some information which I mentioned here in the WIPO survey. And as one example of a model contract that you see what's possible in real phrasing of provisions, I've also included a link here. And I want to end with, as Thomas said, with the post-closing duties, because the signature is just the starting point of the relationship. You can do a lot to foster the success of an agreement. So I completely agree with this comparison with the marathon. So keep track of dates, of actions, milestones, deadlines. If you have meetings to help make development or marketing plans, keep in contact with your licensee if you're a licensor side. Having a contract management system with reports, payments, taxes is a good idea. And also keep an eye on the contract awareness. And that's also important for both sides, licensor and licensee, of course, that all staff involved should be aware of the conditions so that you can avoid inadvertent violation of the contract. So that's, I think, that's the most interesting part when you're eating the cake, let's say. Thank you from my side, and I'm looking forward to receiving some questions.
Super. Thank you very much, Karen. We have had a couple of questions in. Actually, it's quite a good one here. When we license out an IP, how long is this valid for? And how do we measure this duration?
Could you please repeat? I had some
Yes, sure, no problem. So when we license out an IP,
yeah,
how long is this valid for? And how do we measure this duration?
it's very much depending on one hand on your strategy of both sides, but also on the kind of IP, because sometimes when you have a patent, you have a maximum duration of the patent, and you cannot restrict your partner afterwards when the lifetime of the patent is over. And if it's just the patent license, then he should have the access conditions as anybody else in the world. But of course, if there is something else which you license, like know-how, it was mentioned in the example of Bowman, then the contract may still survive, but with a different scope. But that depends if it's still valuable for both parties. So.
Super, thank you. And there's another question on, is it possible to limit a license to a particular country within the EU? Or does that come into conflict with free movements of goods? So maybe a more legal question. I don't know if you know the answer to that.
Yes, also I'm not an expert regarding the EU regulations, so there. I mean, in principle, it's possible to go on certain territories. Specifically, if you have it also depends where the IP is granted, of course, because you cannot license in areas where you don't own the IP. But to specify between different countries within the EU, I would pass this on to a legal
a lawyer.
expert.
Yeah, makes sense. Okay, I think I have time for one final question, and the question of how are royalties defined for sub-licenses? And does the licensor, or can the licensor have any influence on this?
Usually the licensor is asking for a share of the sublicense, and of course the amount this share is defined in the contract. And I would assume that you can also talk about a range or general terms for the sub-licensing conditions, but you cannot bind them in detail, of course.
Okay, super. Thank you very much. Thank you, Karen. Wonderful presentation. And we'll see you, I think, just aware of time, but there might be a couple of questions for you coming up in the big session at the end. So now I'd like to move on to the next part of of today's session, which is some case studies. I'd like to invite Sonia London, current president of Licensing Executives Society International, I hope I get that right, and a lawyer at Tacto Tech. And you have two presentations from Infinite Roots and Learn Engineering. But maybe, Sonia, I'll hand the floor over to you to introduce them.
Thank you very much. And I think we have slides. You're operating your slides yourselves, or are they coming up? Okay, so Natalia will be starting. So we have super interesting case studies here for two different technology companies. And we will have first Natalia Drost from Infinite Roots, and after her we will have Stefano Linari from Linari Engineering. And I will let them further introduce themselves and the company, and let's get right away started because we have limited time and the subject matter is super interesting. Natalia, please go ahead. Stage is yours.
Thank you. Organizers, could you give me the share rights, please? But maybe, hi, I'm super honored to speak here to you. I'm Natalia Drost. I'm the strategic projects lead of at Infinite Roots, a startup based in Hamburg. We were founded in 2018, and since 2 years we are the beneficiary of the EIC accelerator by our old name Mush Labs. So we are ending this project by the end of the year. And maybe to introduce shortly the company on the next slide. Yeah, because I changed the slide, so sorry. Okay, then I just tell you something about our company and what we normally do before jumping into licensing. So normally we are a company that is focusing on novel food products and are really generating food products by cultivating the mycelium, so the roots of edible mushrooms in fermentation. And based on the geography, we produce many different fruits from that we want to sell in our own brand. What we discovered though is the process of bringing out the food products as branded products is taking quite some time due to mainly regulations like the novel food regulation in Germany. On the same hand, we were developing the technologies to do this product since 2018 and have a huge IP strategy behind it. So what came up also from investors is the idea, hey, why don't we generate also value from our technology licensing? And this was twofold before bringing our products to market. So this is not from the table, just as a different route and a new business model that we haven't thought about so much in the beginning. And what we saw is that with technology licensing, or what we thought, we can already show our market potential and that our IP strategy and technology viability is great by having the first licensing contracts. And we have first immediate revenue generation even before selling our food products. Lastly, the knowledge gain, because some of our technologies are not fully scaled up yet. So finding a partner, licensing partner that scales up with you together with his knowledge is, of course, a huge upside. in this field, and also the access to resources from the other company in the licensing agreement. And of course, then in the long term, there are many upsides, like expanding technologies, a sustained revenue stream over the whole term of a licensing contract that are normally very long, expanding the market reach and collaborations through huge partners that were first interested in the technology, but maybe then later can help with the products, and of course, continuous learning. So, and which technologies did we license? So when you go to the next slide, a little bit around our business model. So what we do is to create these food products I meant, we first want to use sustainable technology as much as possible. So in every geography where we want to produce new food, we identify a byproduct from the industry. It could be brewer's spent grain, orange pulp from juice production, and so on and so on. There we have technologies patented that extract the nutrients of these leftovers that would normally be wasted, and these can be used as fermentation medium. So this is technology number one. Technology number two that we have is using this medium in fermentation of the roots of edible mushrooms, and there are 2,300 species. And the parameters to optimize the fermentation of a certain strain, this is technology two that we can license. And then comes the end products that are just sold as B2B. So these two technologies, we are right now designing our business models, had a lot of help from the EIC and coaches and so on, because we had basically no clue how to build it. And we are right now at that stage, what you can see on the next slide, that we pinpointed for our technologies how our term sheet looks like. And you heard above from that a lot before, so I would stop here and happy for any questions.
Okay, so this is super interesting. Again, you mentioned that your selection of the business model for licensing, this was kind of an additional. So building on what Bowman was explaining, that this is kind of an additional revenue that you based your selection on. So what did you find the most challenging in making it happen? You got a lot of help, but what was the process on getting started with licensing?
So I think really wrapping our head around of what we want. So really defining kind of the strategy A, which field of use do we allow and in which geographies to still protect our core business of branded products, right? So we have to be a bit careful whom we gave the technology to still get our core markets with our technology itself. That was point one. Point two, a little bit also wrapping the structure around it so that we keep as most SIP on our side as possible, because that's very important to us. I think these were the main challenges.
So do you already have licenses, or are you still seeking?
We are still in negotiation process.
Okay,
but on a very good way.
Okay, that's nice to hear. How did you find your licensees who would be interested in your technology?
We are lucky that they approached us. So because there are quite some articles out there around us with our investor Bitburger, which is a brewery, and the technology that we have for upcycling brewer's spent grain, we have reach outs of other similar companies to us.
Okay. Did you use potentially any patent analytics or something to scout the market, or did you just build that on your own visibility?
No, we do that. Like, we have an internal IP lead with a lot of experience who worked at the chemical giant BASF before. So he does it very regularly and set up our strategy, but also he is in close contact to IP lawyers that we have that always bump back and forth. And I think that's super critical. Without his knowledge and all his inputs in these projects, that would have been much more a hassle and non-transparent. Yeah.
So when talking about getting started with licensing, what was personally for you the biggest challenge to overcome?
I would say finding the right experts that could guide us through there. We started with just Googling and being like, okay, let's read some books. but very quickly ran into the fact that, as was just said in previous talk, it's so complex and so different for each individual that it was impossible. So having the EIC and really coaches on the technology that I have understanding our problem, that was a great help. And I think having this, we structured our first head of terms in 3 or 4 weeks. And I think without that help, it would have taken months or so.
I understand. I just have to put in my 1 cent that all the people who are now online, please check lesi.org, because licensing executive societies will have experts, so that they will be maybe a little bit easier to find. And of course, please check also the IP Helpdesk services, as have been said before. So one more question for you, Natalia, before we go on with Stefano. So what would be your advice for companies, technology companies that are considering licensing?
Prepare, like really prepare the term sheet and everything internally, and also check it with the board. Check it with the board and all investors, because what we saw when these giant companies approach you as a startup and want to get the licensing agreement, they will try everything to push you back. So what we did for each head of terms, we have a start negotiation and stop negotiation and everything in between. And this we aligned with the board and with all the leadership to know when we step out, so where is our pain point and when we go on. And I think that helped us really to be more confident and not let us push around so much.
Thank you. That's an excellent advice. I couldn't agree with you more, having been working with startups a lot. Support from your investors and board is crucial, especially because you will be able to also make a big mistakes if you are adding business models or changing them to licensing. So thank you for that. So next, I would ask Stefano Linari from Linari Engineering to go through his case. Thank you.
Thank you, Sonia. Hello, I am Stefano. I'm the founder and CEO of Linari Engineering, and we was a startup, and now we are over 20 years from the foundation, and we are beneficiaries of EIC transition project that will end in 25, called it the Nano Wings. In my presentation, I want to tell you, oh, sorry, too fast. Two of our experience with licensing and using of patents, because our latest technology is a patent pending anti-ice nano coating. We invented the nanomaterials, and thanks to EIC funds, we are testing in field with Green Power, that it's operator of wind farm, and with DTU that support us on a technical setup and performance monitoring. In this case, we decide to exploit our patent mainly ourselves, because we have enough technology to produce the material, but a lot of know-how that is still inside our company. And then we can produce this coating and sell and provide, and this we are addressing it with business acceleration services of EIC, the application. So how to use it, how to put in a stable way in a strange surface like wind turbine blades. But when I was young, because now we have 25 persons, but about 10 years ago, I was alone with just 1 employee. And we discover, or we invented another markets completely different from what we are doing now. That is a robotic gas hub. So a robotic system that you can use to replace your knob on in your kitchen and control from remote with inside a miniature brushless motor, inverter, a wireless interface, and a mechanical connection. It sounds good. We have for me was like a Christmas. So to meet the innovation manager of probably at the time the world largest good food appliances manufacturer. They was interested, highly interested in this technology. They see the patent and they, wow, it's fantastic. The best invention of the last century in this trend. We want it. Good. But unfortunately, Stefano, you have just a problem. You have just a drawing. And we need that device that must be validated under gas regulation in EU and US. So we need a prototype at the end. But we are not able to do that. If you will be able to do, we'll be happy to pay for the prototyping phase. And under this condition that the prototype can pass certain stages of certification, the license agreement part, because actually we have a production pipeline of several million pieces per year, and we can provide you a reasonable fee on each knob that will be produced with your technology. It sounds great. So you can imagine that that was Santa Claus. I was very an expert on it. I was focused only on create a strong IP. So I asked for the IP consultant to write the good pattern because I was scary about, and I was stupid also, on the fact that they can grab the technology. But this is not the point. Before me, many persons have still explained that IPR is not the most critical part. It's the licensing part, the tricky part. So the IPR effectively is very strong. They perform FTO great. Nothing to tell about the patent. But we have to see if the world is working. So we have a deadline. The prototype must pass the CE check and the market test. The European largest fair, imagine 200 square meter booth, in the center, just one product, mine. All the visitors touch the prototype, use the prototype for 5 days, 12 hours a day, and the prototype worked perfectly. It was, an party for every dinner. So me and the licensee, we were happy. The launch was perfect. But we came back very happy. We see €1 million each year coming down. But one person changed it, just one. Unfortunately, the global marketing leader, that after 6 years of joint development, decide that street price of the product is too high. No one will buy it. Why? We don't know. It's too complicated to start produce mechatronic components. We produce just a simple pipes and nice glass. We have even to set up these things for so high price. Stop the project. Bye-bye, Stefano. No, you can understand. We were not for sure in the license agreement. We put some fixed amount that they have to pay for all licensing period. But it was something that was 10,000 euros or several 10,000 euros. Yes. With a company that built 40 billion per year, means 1 billion a week. You can imagine what are my fixed fee. Neglectable. So at the end, what I have learned, okay, if I have an IP lawyer that support me during negotiation, term sheet, and the structure, for sure, I can write a better term license agreement. But another important thing is this big company, after this license, I have several other trial to license. They usually push too much on their side. So be ready to out from a Christmas party. Can be happen. You can, yes, you can avoid to spend a lot of time, a lot of effort for a neglectable return. Just last, I don't know, good news is even this big giant want to don't pay innovation, they must pay attention, because now this company in many countries is close to bankrupt, and they are in strong crisis because I don't know why, but their product are completely equal and not from low cost one, because they never invest in innovation. This is my of knowledge.
Fascinating, Stefano. Thank you for that. I can relate to that because this is often seen in manufacturing, that the manufacturing costs may kill your project. That's one thing that could happen. But also, what is one learning of this story is that if you don't innovate, you will die. And that can even be the case for bigger companies, and that's why licensing is so important also for big companies to be scouting on good solutions. Well, now that we know what went wrong, that you didn't have clauses to get you out from the deal, did you see warning signs? Could you have made something differently in your licensing process? What would you have done differently now looking back?
Yeah, now we are negotiating new other licenses of our technologies, and for sure the possibility that the licenses decide to deliberately do not exploit the patent. This does not mean low sales because market don't look like so. Reasonable commercial effort are included in our previous license agreement, but no commercial effort if no product in the catalog. So we have to handle this option. And second, be scary from my perspective from innovation department of big corporation, because their metrics is how many technology they catch and onboard. Different story is for business line. So closer as possible to business and marketing guys. And okay, the entry point are innovation, but the pocket is in the hand of marketing and business.
I get that. Yes, I agree. Before we go to the general session, we are a little bit late of timing now, but I'll just ask one final question, Stefano, for you. Now, what would be your advice to a company that is considering a licensing business model, for example, against the possibility of manufacturing themselves? What's your advice?
I can suggest, if possible, to move to a license, because with our company, we are manufacturer and we know how far is the IP from the productization of one technology. So if you have the possibility to grow fast with a licensee, usually it's better, especially for a startup.
Thank you. That's great advice. So let's keep that in mind. It's a great opportunity to create entire business lines or just an additional revenue. Thank you, Natalia. Thank you, Stefano. I will move back to general questions for Tom. Thank you.
Super. Thank you, Sonia. Hopefully my camera will turn on. Yes, there it is. It started to take a little while to turn on. So super. Thank you very much, everyone. We're now going to have a large general question and answer session with all of the panelists. So if I could invite the other panelists back onto the stage. Gosh, lots of people. It's brilliant. got a couple of questions in. So the first one actually is more in the direction of Natalia and Stefano, but I'm intrigued as what other people think. So if IP plays a key part in your licenses, of course it does. What measures can or do you take to minimize the impact if the value of the IP suddenly changes? For example, maybe if it's patent pending, it's then granted, or the patent is not granted. How do you try and minimize that sudden impact?
Sorry, can you repeat that just quickly?
Yes.
I didn't get that.
Sorry, I spoke too quickly, I guess. Sorry. No, it's really just what measures can you take to minimize if the value of the IP changes sharply? For example, a patent pending might be granted, or a granted patent might be revoked.
I would think that most of the licensees would require some kind of a protective clauses around that. In my experience, unless you have a really solid know-how, patent pending is not a great thing to start with in licensing. You should have a patent granted, and then if you have a good know-how on top of that, then that will help you further. Then if that patent is in the end not granted, that will destroy a lot of value, not everything, but a lot of that. So it would be good to have a protective clause to at least enable some kind of negotiations. I think that would be required by both parties ultimately.
Super, thank you. And Thomas, I see you have your hand up. You're muted, Thomas.
Yep. In many cases,
we still don't hear you. I don't. Not sure, Thomas. I think we've lost you there. So hopefully we can get you back to answer that question later. A question from the audience, though, is what's the best source for royalty rates for different technology fields?
I will chip in immediately, because if you are an LES member, you will be able to get the royalty rate survey for free. So there's a good value there. That has that's generally covering high-tech areas, and then there's a special section for pharma. So it's not like covering all, but it's a good suggestion.
Super, thank you. And we have another question coming. Lots of questions come in, so this is good. So when a licensing deal is terminated, what should be the grounds that we mention in the term sheets? And how do you work out what kind of compensation is or would be involved? Maybe Stefano, that'd be a good question for you, obviously, because you had to, or you weren't able to terminate it, but you sort of.
Yeah, I think my experience is not so positive about that. But, I never experienced this point because my termination is a natural termination of the contract and nothing more. So it's worth terrible.
Okay, thank you.
So usually you have some reasons included that enable termination of the contract. But of course, what you always take care of is that you secure a second chance, or when you have given an exclusive license and you terminate the exclusive license and you want to have a second chance or a third chance, then you want to have all the IP, everything that is going along with that secured, so that documentation is handed over, that all the rights are given back to you, including improvements that were made, so that you have a fair chance to have an attractive package then for potential licensee to get the technology in use. So that is a typical provision. And coming back to the question before, I think it's also important to have a price tag allocated to the different components when you license the technology, and not only the patent, and you have know-how. and you have patents that are granted in different jurisdictions, and then you get troubles, and it is either patents lapse or patents are not granted or challenged, then it should be clear what are the consequences. So that means, is the royalty rate, for example, reduced, and is only then paid for the know-how that you have transferred, so that you have foreseen that in the contract, that you, or you have installed a mechanism how you negotiate these aspects, so that you have defined the process, how to get there, which expertise to be used, what are the arguments that are valid, then to change the royalty rates, that it is still fair, still putting the licensee not in a worse position than any third party. That is also, for example, not a fair thing. You want to have a fair agreement that is beneficial for both.
Definitely. Super. Thank you, Thomas. Anyone else like to comment on that? No, super. So we have another question coming. It's actually a question that came in earlier, and it's linked in a little bit also to what Sonia said. So I think I know Sonia's position on the answer to this, so there's this already. The question is saying that if we don't actually want to apply for a patent ourselves, can we license the technology out to or to a different partnership to then use that technology and apply for who then applies for IP protection themselves? So maybe I know Sonia's agreement is you should have the patent granted first, but maybe you could comment on sort of the pros and cons of that as a strategy. I mean, as I said, obviously you don't then have to invest any financial yourself because the licensee is then paying for the patent, but the risks involved.
Well, I would still recommend on having the patent for yourself first. Secure the right first, and then start to negotiate. Of course, you can agree all kinds of stuff, but what if it doesn't go as expected, and then you don't have the right that you can enforce? So that's the question. You can always agree on all kinds of creative structures, but if you are not in control of that IP, then it might be gone if things go bad.
Thomas, I see you have your hand up.
Yes, so I think that is perfectly right what Sonia is saying from a business perspective. When you have IP competence in your company and you can run the process, that all the IP management infrastructure is in the company, it makes perfect sense. But in practice, I have also seen, for example, some universities not having critical mass for an IP management system, closing a contract that potentially can last 20 years, 30 years, and they don't know if they have the technology licensing office still financed the next 3 years, then there's a disbalance. And there have been many situations where it made perfect sense to hand over the whole IP management to the company, to the licensee, so that the licensee who knows how does the product look like, then better understands what claims you need for covering the product, in which nations you need to have the filing done, which geographical coverage you need, so that then the competent partner in this relationship takes over these aspects, and you avoid a lot of friction between the two partners, and you secure the long-term use of the technology. So there are situations where it makes sense to consider an alternative path, but it should not be just for convenience, So because it can pay back badly if you're just too lazy to do the work and you say, I play to the other field and I trust in God, it all works out fine. That would be a little bit naive.
Okay, super. So Karen, maybe I could put you a little on the spot as you're involved in this on a more day-to-day basis. Does this happen much to you at the university?
Excuse me, what do you wanted me to add?
Yes, just if you had anything to add, because you're obviously working with this on a day-to-day basis of technologies coming through. Do you find that you are better off, or do you have experience really where you as the university protect the IP and then license it out, or just bring out the unprotected as part of the license and let the spin-off company or whatever take the license, as in apply for the patent themselves?
Usually we try to secure the IP ourselves. It's only in the conditions where we already have very good working relationship that we and have projects together that we are considering of transferring the IP before it's secured. Or we also had very successful cases where we had found the partner and then with the unsecured IP, and then build up the IP together and filed it in both names. So
Okay,
that has been also a possibility, which worked out quite nicely.
Super. And then I might then. Sorry,
Tom, I think you have asked the wrong university, because TU Wien has a long tradition in that area, has a lot of competence, has critical mass, and is running that very professionally.
That was in part why I wanted to ask, you see, because I wanted to see if...
Yeah.
But there are universities, where one person who is in charge of many other things as well is handling that. And the one-man show at a regular university that usually does not guarantee that all the capacity, all the competence, and everything is in place. And when it's so difficult, then it's I think a valid approach to hand over things to the licensee and let the pros do the work when you have to accept that you don't have the resources that would correspond to what is required.
Super, yes. So I'd also then, in that sense, fire the question over to Adela from the EIC perspective. Obviously, from a funding viewpoint, would it make a difference if the company coming to you has the patent in their name or not?
No, we can't hear you.
Okay. So it wasn't just a stunned silence.
How about now?
Yes, we can hear you now.
Yeah. Okay. Just to understand the question, so you are referring to the application process, right? If
yes, it's just
somebody is applying
where...
to the EIC, if it gives them an advantage, if it increases the chances to getting the grant from us if the patent is owned, right? That's the question.
Yes. So if they've licensed the IP and then applied for a patent in it themselves versus the university, wherever they got it from, had the patent.
Mm-hmm. So in principle, I would say it should not make any difference for us. So it does not. I would say it does not matter whether the patent is actually owned by the applicant or whether it is licensed in. But what has to be demonstrated is that the applicant has kind of rights over the patent. Yeah. So you either have to have an ownership or you need to have a license in place. So you need to have control over the technology. And that actually brings me back to the IP strategy. So basically what is important for us is that you have IP strategy. And so you need to have a plan. You need to know what you are doing. You have to make sure that you are securing all the rights that you need. And whether it's via ownership or via a license, I would dare to say that is not decisive for us.
Super, yeah. That's what I expected you to say, but it was good to check. And then I guess maybe you can send this question to Stefan and Natalia. From you, as obviously as small companies, do you see it as maybe as a risk if the person you're getting the technology from doesn't sort of trust it enough that they will apply for a patent themselves, or do you see it as an advantage that you then have it more in hand as to what's going on? Maybe Natalia first.
Right now, I can just say that we are in negotiation with the technologies that we have a patent on, so the other way around, because the others are all bigger than us, which shows us that we do kind of the right patents. So yeah. And as I said, our IP strategy is to avoid having shared IP, or that that appears on us. So we really try to protect what we develop with our patents and then license them out.
Yeah. From my perspective, even I'm following what Natalia, Sonia told before. It's still difficult to create a licensing strategy with a solid IPR. Without them, I think can be quite impossible. Like, limited experience, but yeah, I think it's better to start at least with a solid things to negotiate on.
Super. And Christian, sorry, I just realized you haven't said anything. If you had any comments to make on this topic. Oh, you're muted, Christian.
Yeah, no additional comment.
I think we've covered it in quite a lot of depth now, so that's good. I'm just conscious of time. We do have one final question. It's an interesting one. Is what happens to the license agreement if the licensee is acquired by another company, maybe through a merger or acquisition, and especially if trade secrets are part of the license? Does anybody want to volunteer to take that one?
I can start because I've mentioned it a little bit in my talk that you have to think about this already regarding the license agreement and make any provisions if the license can be transferred, because from the license source perspective, it can be quite changing because you might have a direct competitor afterwards as a licensee if the license is transferred, and so you might have the possibility to get it back. So you want to have control over whether it's transferred or not.
Super. And Thomas?
Yep. So we had that in many license contracts included, where it was critical that the technology, when it was non-exclusive licenses, and the licensees, they wanted to avoid that the fiercest competitor gets it into their hands. We sometimes even had a list of companies that defined the kind of red line. So if the company, the licensee would be bought by one of these companies, the technology would fall back. So that we had to clarify that in advance, how that in which case it works and how does it work to secure the interest of the licensees. So it's an important point to consider. And not only for that reason, it's only one of the reasons why it can end up in a very different, it can take a different path than you thought about when you licensed out the technology. If something is a game changer like that, then you want to still have a say, an option to control that.
Super. I think that seems to be a general theme we've come across in this session, that it's very important to have the right clauses in the contract, because if you have them, everything becomes much easier, and if you don't, you can end up in all sorts of trouble. Sometimes just very unintentionally with events that you wouldn't have thought would have happened. Super. Thank you very much. I'm aware of the time. I'd like to thank again the speakers for their part.